So hi everyone, welcome to Estate and Financial Planning in Your 40s. I'm Ian, I'm a Chartered Financial Planner and founder of Work to Live Financial Planning. And today we've got Vicky from Myerson's, who's head of wills, trust and probate, and wanted to put on this session, having obviously worked a lot with people in their 40s, professionals, business owners. And one of the important elements is obviously making sure the estate planning is right. There's a lot of changes kind of coming down the line as well. And I think it's something that's really important to kind of visit and to be looking at for people as well. It's something that can sort of be pushed to the background or overlooked, or think it's for someone that's a bit older. So I think it's a really important area that people need to be considering. So Vicky, do you want to just give a very brief introduction to yourself?
Good afternoon, everyone, and thanks for inviting me to attend, Ian. So this is my first LinkedIn Live, very exciting. I head up the Wills, Trust and Probate team here at Myerson, and we do work with a lot of clients starting, I suppose historically, private client matters are normally dealt with for people slightly elderly, getting into retirement, but a lot of our clients are clients with businesses and start quite early on. So we probably work mid-30s, 40s upwards. To retirement age. So we specialise in wills and estate planning, inheritance tax planning, powers of attorney, trusts and everything to do with succession.
Fantastic. So a lot of stuff we're going to cover off today, and we've got a case study that we're going to go through. But before we kind of jump into that, obviously you mentioned it. I think when people think trust, estate planning, they automatically go, "Oh, that's for maybe my parents or grandparents." But you still see more people seeking advice in this area that are a little bit younger?
Absolutely. I think I probably even start younger than that. When people come out of school, maybe starting a job, you end up paying into a pension. You might have death in service, and especially when you maybe buy your first house, you're accumulating assets already. So I think it's quite important to start early and think about your finances and how you'll provide for your family, yourself, and the future. And I know retirement sounds like a long, long time away, and that's normally what it sounds like to me as well, but it slowly creeps upon you, so definitely worth starting early.
Yeah, I think that's really true, and I think it's important to do it as early as possible, and it's that thing to revisit. I think I did my wills maybe 7-8 years ago, and I know we're speaking about updating them because circumstances have kind of changed. So why in particular sort of for your 40s with estate planning be so important?
I would say for your 40s, a lot of people might be married, settle down, they might have young children, settle down in their careers, they may be starting a business, they're accumulating wealth at this stage, you'll probably own houses, you may be inheriting. So there's lots of aspects where you are building wealth, and I think when you've got more responsibilities, especially with young children, that's where you would start thinking about, well, how do I make sure I'm not just providing for me and my spouse, but also children, future generations. So I think 40s is a good time to really start looking at things if you haven't started already.
Definitely. Okay, so we'll jump into the case study. And just again, obviously, with regards to the presentation, everything is information only. It's not advice, which should be based on your individual circumstances. So just cover off the regulatory bit. So the case study that we've got Jack and Jill, both sort of mid to late 40s. They've got 2 children, Jenny, who's at university, and Johnny, who's 14 and has learning difficulties. Jack is inheriting $500,000 following his father passing away. And again, something in your 40s that's probably happening to people reasonably regularly. Got a primary property, and they've got a holiday home as well, business and income, and then a few kind of pensions. So I guess start with the first thing people think about when it comes to estate planning is the basics, and that's the will. So do you want to sort of give us your thoughts in this particular case?
Yeah, so for wills, I think there's always the assumption that, well, in your 40s, you're probably invincible and you're never going to die, so you don't need a will to start with. But then the second thing is there's, again, an assumption that if you die and you're married, it will automatically go to your spouse. And that's not true. it's dealt with under the rules of intestacy, which look at how your assets are held. So first of all, any assets owned jointly usually pass automatically to the survivors. So what's in your estate are things in your sole name. Sometimes for various reasons, you've got maybe the main house in somebody's sole name. So that will only pass by the terms of your will or intestacy rules. And if you are married with children like Jack and Jill are here, the first thing you'll be looking at is the first 322,000 passing to a surviving spouse, and that may or may not even cover the primary residence. If you look at this as an example, it doesn't. And then the balance over 322,000 will be split 50-50, so 50% to the surviving spouse and then 50% between children. And normally that's held on trust until the children are 18. So here you've got Jenny, who's 18. She would inherit a quarter share. But if something happened and Johnny's still 14, it's held on trust for him until he's 18. Now, Johnny's got learning difficulties here. So again, is it suitable for him to have a large chunk of money when he gets to the age of 18? So I think a lot of people assuming that it'll automatically go into the surviving spouse would be wrong here, and it probably wouldn't. The intestacy rules accord with what their wishes are.
Yeah, and I think it's an interesting one as well, because what will happen to the kids if there's no will? Obviously, Jenny's a bit older in this case, so no longer probably classed as dependent. But if the kids were a bit younger, let's say they were under 10, you haven't got a will in place, what would actually happen?
Well, I think actually if you look at anybody under the age of 18, by law, they're still a minor. And although they can probably go off and get married at the age of 16 and disappear, in terms of who looks after them and makes decisions, etc., if there's one surviving parent from Jack and Jill, then the other person will remain as a parent. But if both of them die, for example, in an accident and they're away together and Johnny's left, then you would need to be thinking about appointing a guardian to look after Johnny and make welfare decisions for him.
Yeah, because if you don't have one, then the court potentially will decide who looks after your kids for you, and that may not be the person that you actually want.
Potentially. I mean, in this case, Jack and Jill are married. There's quite a lot of situations where you've got maybe parents who had a child together, but they're no longer together and they've split up now. And the parent who's not there may not be suitable to act as a guardian. So if it goes automatically to the other person, it might be a grandparent comes along. There might be both sides of the family interested in looking after the child, and you don't want your family falling out and battling it over in court as to who's going to be a guardian for Johnny.
Yeah, so I just think it's really important, isn't it? It's not a nice conversation to have, but it's one of those conversations that need to be had. And again, I use my own example here to update the person who would potentially look after your children. When we set up our will originally, that person is no longer actually with us. So things kind of change. And then also the person that, if we were doing it now, we wouldn't want them even if they were around to do it. So, the circumstances do sort of change. So with regards to the learning difficulties, Johnny, how would you kind of look at managing that and making sure that he's going to be okay, and, assuming that, we're not going to be in a position to maybe manage the money himself?
So there's a couple of things. Of course, practical steps are how severe are Johnny's learning difficulties and who is able to look after Johnny and understand what he needs. And it might be that somebody works alongside Jack and Jill whilst they're alive. And if something happened, that would be the person who would step in to look after Johnny. And that role we've already talked about is a guardian. But also if both parents died, you've got the other aspect of it, which is the financial aspect and who would look after the funds. So then you'd be thinking about appointing executors and trustees. So the executors would administer the estate. Normally that involves looking at what the assets are, valuing the assets and liabilities, applying for probate, dealing with any tax. But then after that, it's then distributing the assets in accordance with the terms of the will or the parents' wishes. And that's then managing the monies. And you might have different people managing the money to the guardian who's making day-to-day decisions. And sometimes you might have the guardian act as one of the executors and trustees alongside a second person who can keep a check. I have had clients ask me whether or not it's fine just to have it the same person as both, and you can, but it's that extra check to make sure that person isn't spending the money on things they shouldn't be spending on. For example, Johnny needs a holiday to Florida, but that means I have to go, my other half has to go, and all my 3 kids have to go as well. and that'll come out of Johnny's funds. So it's just keeping a check on the finances as well.
Yeah, it's a really good point. I always say to my clients, the person that you looks after the finances may not be the person that you want to look after your kids, and vice versa. There's always that argument of, see, if kids have lost their parents, oh, those poor children, you almost fill them with kindness and spend all the money, and that's how they are, because they're such a nurturing person. But actually, is that the person that you want with the inheritance and everything that you set up for them? So they can be two very different people, and I think it's really important to kind of look at the type of person and what you want in each situation, and not just assume, well, they're looking after the kids, they should look after the money. You might want to separate them out. But yeah, definitely that thing of, oh, the poor children, so we're just going to spend all the money to try and make them feel better, which is a totally understandable thing to do, but it's probably not what you kind of intended. You almost need someone who's there to go, actually, no, that's probably not the way forward.
Yeah, so I think trusts are probably going to be useful in Johnny's case here if his learning difficulties are very severe, or if he's just kind-hearted. And I think a lot of people tend to lean, oh, I need something for this, and it could be that Johnny's like, I'll help you, here's some money type thing. You don't want Johnny to be able to be having a big pot of cash where potentially he could be spending it on other people rather than himself. So I think a use of a trust here would be very helpful, and then having trustees in place who can assess Johnny's needs. And as he gets older, he might sort of learn more skills, life skills, dealing with finances, and maybe he can be a little bit more independent. But whilst he's needing that help, the trustees can assess and then decide as and when he needs the money, and perhaps make payments on his behalf so that he's not in full control, and it could be, spent on things that shouldn't be spent on, or giving it to other people.
Yeah, absolutely. I think we can spend ages just on that, but we'll move on and start talking about like the liabilities and that side of things. So there's the outstanding mortgage that's in place. So how would you sort of look at people in this situation? What would you be suggesting for them?
So I think here, if you died suddenly and there's such a large mortgage outstanding, it's if you're not wanting to uproot and sell the home, if you can't manage on, again, a couple of things. It's one, income, will that be enough if one person passes away? Discharging the liability, uprooting. So it's all sort of practical things about it. And you might be thinking about putting in place some sort of insurance so that if something happens, it will pay out enough to cover the mortgage. So I think this is probably more you than me, Ian, and we would normally sort of say refer you to somebody who could look at putting some sort of policy in place to cover that, and that would be life cover and maybe income protection as well.
Yeah, absolutely. I think it's different with business owners and people that are employed, but I think a lot of employed people, oh, I've got my death and service and I've got maybe the mortgage covered, so that'll be enough. If you're earning a substantial income, your expenses are liable to be quite high. So how long will that actually kind of last? Would be one aspect. And then for the business owners as well, there's, what happens to the business. I mean, Jack in this case is 100% share, and the company's valued about 3 million. If Jack passes away and he's the person that makes the business happen, is it actually worth that? Who's going to take over the shares? What's going to happen to it? So really lots of elements to think about. Income protection is always a big one. Always talking to my clients about protecting the income. The risk of you dying is quite small, but you definitely want to have something in place. God forbid it does happen. The income protection as well, an absolutely massive one. You'd never want to be in a situation where actually something happened. You'd be better off to your family if you passed away rather than survive. So 2 areas to really look at. And then again, something that I see a lot of people overlook is limited company and relevant life insurance, where the business takes it out, super tax efficient, puts it into a trust for your beneficiaries. Just a great way of making sure that they're taken care of and protecting as well. So if you've got any personal insurances and you're a limited company, it's relevant life is something that you absolutely should be looking at. And then again, making sure it's written into a trust as well. Just if for nothing else, to streamline the process when it's being paid out and not having to go through probate and all that kind of hassle. So yeah, I think it's really, really important that, insurances are a lot of that. Again, not my conversation to have. I always say it's one of those things you think about it once, it's done. You can put it in a drawer and hope you never have to think about it again.
I think on the business side, what we're probably looking at there is shares, probably not typical setup where an individual owns 100% of the shares. There might be other family members involved, but in terms of, like you said, Jack being the key man, there might be other person that's relevant in the business, and you'd be thinking about looking at the shareholders agreement articles in terms of what they do say, what they don't say in terms of transferring shares, etc. And also, of course, we've got the 3 million value. One of the things I think we're looking at, and most people will be aware of if you do own a business, in the last autumn budget, something called business property relief for inheritance tax purposes. If you have a qualifying business interest, then at the moment it could be 100% exempt. So if it's 3 million, it could be a full exemption. But in the autumn statement, one thing that was picked up was now for both business owners and farmers, and of course everybody will be aware of Jeremy Clarkson and all the farmers going out with the tractors, that this will now be limited to £1 million for the 100% relief, and then anything over and above that will be taxed at half the inheritance tax rate. So inheritance tax would be taxed at 40%, so half that would be 20%. So if we left things as they are now, Jack would get 100% relief on £1 million, and then the 2 million over will be taxed at 20%. That will be coming into effect, and there weren't any changes in the spring budget. That will be April 2026. So that's another sort of thinking point and potentially estate planning point where you can maybe share and redistribute some of those shares in the business to try and maximise reliefs, given that they're going to be reduced quite significantly in a very short space of time.
Yeah, absolutely. Some big changes there. Don't know exactly what it's going to look like when it all comes out in the wash, but again, just another area that people really need to be considering. Before we move on quite quickly, if anyone does have any questions, fire them into the comments and we'll have a little bit of time to answer them. So with the business and the changes that are coming, I mean, I guess the question I would ask is where do you start with it? Is there a particular order that you should be looking at? Because there's quite a few kind of areas. So is there, does it vary by people, or this is what you want to get sorted first and kind of work through it?
For estate planning, you can only ever do a snapshot. If we had a crystal ball and knew when we'd die, number one, it'd be rather scary. And number two, I'm not sure. Things change anyway, as we well know. For today, it might be one thing. Another government comes in, and we end up with something completely different. Again, if we change from a Labour government to another government, they may change it back. So in terms of estate planning, you can only plan for what you've got now, and based on the valuations at the time of death, everything has to be revalued and looked at. So what you want is some flexibility to be able to reassess the situation at that time. So work with what you've got. We would always say, I think Ian, you mentioned you did your will probably 7 or 8 years ago. We would probably recommend to people, if there's a major change such as the law or in your circumstances, maybe somebody's passed away, minimum you'd be looking at reviewing your estate planning would be every 3 to sort of 5 years. I would probably say, just if you have a will in place, just cast an eye over it every year and see what it says, because you might find if somebody's died or you've inherited some money, like in this case, you might want to do something different and maximise what you've got and reduce some tax. So it's worth constantly reviewing.
Yeah, absolutely. And yeah, it's a really important thing to constantly be looking at it. Just a couple of things to kind of close off that just want to touch on. What about Lee? So Jack's getting a fairly sizable inheritance. He's already got a decent size estate. Anything he should be thinking about?
Yeah, so it's not. I think it's one of those things where later on, sort of 50s, 40s, 50s, 60s, when parents start passing away and then passing wealth on. If you don't need it, it is possible for you to do what's called a deed of variation. So a lot of our clients who've built up their own wealth and will likely keep growing their own estate don't need this extra money, but if they want to make sure it's available for them or even directly pass it to the next generation, they can execute what's called a deed of variation. And provided it's done within 2 years of the person's date of death, so this is Jack's father, you can, for inheritance tax purposes, treat it as if Jack's father had written it into his own will. So instead of dropping it into Jack's estate and then Jack thinking about having to do something with it, for example, gifting it away, and if you make gifts, you have to survive 7 years before it falls out of your estate, it will be treated as if Jack's dad had made the gift to, and it could be into a trust where Jack and his descendants could be potential beneficiaries, or it could go to Jack's children later on particular terms, but then Jack wouldn't have to survive 7 years. So that's another really good tool that people could use when inheriting funds that they may not need.
And again, a key to sort of take advice on that side of things. There's one final thing, and I don't want to overlook it because I think it is overlooked by people, ironically, is a power of attorney. So just talk us briefly through that, Vicky, and how important that is.
Okay, so powers of attorney, I think a lot of people get confused and mixed up and say, I've got a will, I don't need a power of attorney. Powers of attorney don't ever cross over with wills. It's something you make for your lifetime if you should lose mental capacity. And when you die, that completely stops, falls away, and the will kicks into place, and then your executors and trustees will manage your estate. Powers of attorney, they are now the most up-to-date version called lasting powers of attorney, and they're two different types. One deals with property and financial affairs, and the other one deals with health and welfare, so people will make decisions on your behalf. So for the health and welfare one, you would only ever make decisions, somebody else would make decisions on your behalf if you've lost mental capacity. So if you're in a coma or something happened and you can't make that decision, you've had too many drugs, and it's not you sort of unconscious and you can't do that, somebody would make that decision for you, and that can extend up all the way up to life-sustaining treatment as well. So you might want to say, I don't want to be resuscitated. The health and welfare one is a bit more restrictive, and it keeps the individual making their decisions until they lost capacity. But for the property and financial affairs one, that's really, really useful. So you can use it two ways. One, personally, for dealing with your day-to-day bills. In this context, you might want to do a completely separate one. So if somebody's a bit more au fait with dealing with the business, but you don't want them dealing with your personal financial affairs, you might have a separate business LPA in place where maybe a co-business owner who can run it will run it and just deal with the business aspect, and your home life is dealt with by somebody completely different. And the property and financial affairs one can be used out of convenience. So if you're away on your nice holidays for a couple of weeks type thing, somebody can pick it up in your absence. So they just need to be made, signed, or attorneys agreed, and sent off to the court for registration, and then they could be used whenever you choose.
Yeah, I think it's an overlooked thing as well that people don't realise. If someone loses capacity and if a bank finds out about it, which they will and they should, how difficult it then is to get money. Though essentially the account goes, if it's it's in there, and let's say like most of the money is held in that person's name, then and you need that money, you're going to have a real challenge. So that's powers of attorney are really, really kind of key thing. And with anything, it's having the contingency in there, the disaster planning. We're looking at worst case scenarios that, touch wood, would never happen. You want to do the planning while you think about it and be able to do it rather than having to, I would say, be proactive rather than having to react, because once you have to react, it's going to be too late. And the last thing you want to do is be burdening people with these challenges when something severe is happening, their health, maybe they're grieving, they're dealing with all this stress, and then you're going to throw on a load of financial and other issues for them as well. And it's an administrative nightmare if someone dies as well as it is. So I think the easier that you can kind of make it for your beneficiaries and people who are dealing with your estate, the better. Yeah. So I think that's it. I'm not sure if we've got any kind of questions, but I'll just do a very kind of quick recap on some of the stuff that we discussed. So your wills and appointments. So, trustees, who do you want to be taking care of the kid? Who might want taking care of the money? Guardians for the children. Again, they might be different people. Trust to protect, inheritance and the assets could be something. Disaster planning, make sure you've got the right insurances in place. Don't put it off. I've had 2 clients that have had to sadly claim on these, and it does help and it makes a big difference. And someone got to keep their house because they have this policy in place, which was a big thing. Inheritance tax, there's a lot of changes coming around business property relief. So again, if you've got a business, it's definitely something that you want to be looking at as well. And the power of attorneys, often, like I say, probably overlooked, but a really, really key part of any planning that you should be doing around, contingency and disaster planning and stress testing, what would actually happen. So any kind of final thoughts?
Very quickly, I think just on pensions, again, that's due for change as well, isn't it? At the moment, they don't form part of your estate for inheritance tax purposes. But again, the autumn budget mentioned that from April 27, they will be pulled back into people's estates for inheritance tax purposes. So again, I think that's depending on what's happening with that and where you are in your stage of life is when you start drawing. Again, you probably want to take advice on that. And again, that's probably more you than me, Ian.
Yeah, the pension changes are going to be a big one on that side of things. So again, 2027, I still think pensions are a really important part of people's planning, but probably moving back to what they were actually intended for, rather than the very nice inheritance tax that they used to give. On that side of it. So yes, that was great. I think some really useful stuff on that side of things. Hopefully the sound came through okay. It was a bit of background noise on my side, so hopefully that's not been too bad for people. But I think it's definitely one that we may want to have another one at some point in the future, because I think it's some really important topics, and like I say, we're probably going into quite a bit of depth on quite a few of them. We'll wrap up there. If anyone does have any questions once they've kind of watched the webinar, we can jump in and obviously answer them or point them in the kind of the right directions. But Vicky, Rick, thanks a lot for agreeing to be on. Some really useful stuff there. So hopefully it'll be some value for people.